Thank you very much for joining this London Business Hub webinar. My name's Ian Robinson and I'm a partner with Fragomen, the immigration law firm. Today's webinar is concerned with Brexit and the new UK immigration system. We're really happy to be able to help the London Business Hub with this webinar. The London Business Hub supplies a range of free, impartial and practical support to help guide all SMEs from the planning and startup phase to the more established company looking for bespoke guidance at this uncertain time. Supported by the Mayor of London and part of the National Growth Hub, we're here to help you find the best possible solutions to your problems, no matter what stage your business is at. Today's webinar is concerned with UK immigration when the UK's involvement in free movement ends at 11 p.m. on the 31st of December 2020. I'm going to be taking the webinar in two parts, two slightly unequal parts. To begin with, I will look at the EU settlement scheme, which is in place for Europeans who are in the UK before the end of this year and able to make an application for pre-settle status or settle status to confirm their presence in the UK. It's really important for employers, but I won't go into too much detail on it today, but it is possible to listen to a more comprehensive webinar that we've recorded elsewhere on the London Business Hub, particularly if you intend to make an application under the scheme. The second part of the webinar will be concerned with the new UK immigration system that will replace free movement and be instigated for migration from all around the world, other than for Irish nationals, as they will continue to be free from immigration control. The new immigration system takes effect from the beginning of December 2020, but in practice it becomes most important on the 1st of January, immediately after the free movement rights of European nationals in the UK has ended. So let's start with the EU settlement scheme. The scheme is available to all Europeans who are in the UK on or before the 31st of December 2020. It's also available to their non-European family members. Irish people don't need to apply under the scheme, but where they have a non-European family member, it may make sense for them to do so. It will make the application of their family member that little bit easier. The system itself is open now and it's so easy to apply. It's available to European people who, for the purposes of today's webinar, we are thinking of EU nationals, EEA nationals and Swiss nationals, again, other than Irish people and of course other than British people. The application is made online via an app and your browser. The app allows you to upload biometric and biographical details from your passport. You take a selfie, you scan your face, answer several reasonably straightforward questions, and it then checks your records against HMRC and benefits data and tells you how long the government thinks you've been in the country for. If it thinks that you've been here for 5 years or more, and that's correct, you will be entitled to what's called settled status, which enables you to stay in the UK permanently. If you've been here for less than 5 years, it will tell you that you are entitled to pre-settle status, and then once you've made up the 5 years residence and within the 5-year grant of pre-settle status, you're able to move to full settled status, again, the right to live here permanently. If the system thinks you've been here for less than 5 years, and that's incorrect, it's possible for you to make an application, for you to upload information onto the app and prescribe documentation to correct that misunderstanding. Overall, the application should take you about 15 or 20 minutes, and for the vast majority of people, it's reasonably straightforward. Again, I really recommend that if you are making an application, firstly, you should always look at government guidance, of course, but you can also find more information on the process elsewhere on the London Business Hub. There is a deadline of the 30th of June 2021 to make the applications. It's really important that applications go in before then. There are few reasons for that. If you're listening and you're an employer, there is limited corporate compliance risk attached to not applying. You will not be expected to check that all of your employees have made an application. But where your employees have not made an application, there is substantial personal risk to them. If they do not apply on time, they will essentially have no status in the UK. To all intents and purposes, could be considered here illegally, and they will find it harder to find a new job, rent a flat, access some healthcare, get a driving license, open a bank account, and otherwise be subject to the hostile environment that exists in UK immigration. And hostile really is, it's a slightly dramatic word, but it's accurate, and people's lives could be turned upside down if they do not make an application where they're entitled to. It's really important that they do. As an employer, what we tend to recommend is just communicate to people and support the applications. Begin by explaining that people can stay and reassuring them. Move on to educate them on their entitlement and the process. Provide information to them, government source information, or from your immigration providers if you have one, that guides them through the immigration application for the EU settlement scheme, and just direct them to make an application before the end of June 2021. You may want to check that people have made an application. You should always be careful there. There is no basis in, or no explicit basis in law for you to insist that people show you that they've made an application. So always speak to a professional, in particular an employment lawyer, on that particular question before you take a decision to insist. Application should only be refused if an individual is considered a serious foreign criminal. That typically, but not always, will mean a custodial sentence of 12 months, but it can differ depending on circumstances and how long a person has been here. So that's the EU settlement scheme. There's an awful lot more to it. You also need to think about absences from the UK before you apply and absences after you've applied. But this is an important immigration status for the individuals, but also for you as an employer. From the beginning of January 2021, there will be a skilled immigration system, which I will come to in a moment, that is not there for low-skilled workers and low-skilled work. It will not be possible to be sponsored to take unskilled work, whereas people holding pre-settled status or settled status will be able to. So this will be one of your options or tactics in your workforce planning when you're thinking about immigration, recruiting people, particularly into lower skilled jobs where they hold status under the EU settlement scheme. Moving on to the new immigration system that will be in place to replace free movement. The system largely takes effect from the beginning of December 2020, but really it becomes important on the 1st of January 2021. Now, if you're an employer who has a long experience of sponsoring European workers, what you're going to find is that this is a slower and much more expensive system than free movement. You're also going to find, as I've said, that you're prevented from recruiting people into lower skilled work in the way that you may have done in the past. They will need permission to work in the UK, whether that's under the EU settlement scheme or on a self-sponsored basis. You can mitigate those impacts by bringing moves forward, but only to a point. We only have until free movement ends at 11 p.m. on the 30th of December, 31st of December 2020. If you're used to recruiting non-European workers, what you're going to find is that this is a quicker system than what you may be used to, whereas in the past, securing somebody for a permanent role in what has been called Tier 2 General would have typically taken between 3 and 4 months. You could be looking at the immigration process taking about a month. This system as a whole will actually be one of the more effective in the world, but it will be hard to see that at times, given that it's replacing free movement, which would absolutely be the most effective immigration system in the world for employers, at least. It is, though, again, remains expensive for non-European workers, and it's no less complex than what we have right now, so don't expect a simplified system. The other important point, whether you're recruiting from Europe or outside of Europe, is that for the skilled worker category that I'll talk to, likewise for the intra-company transfer category, you're going to need to be a sponsor and hold a sponsor license. So, what is a sponsor license? Sponsor licensing is basically an agreement or a contract between a UK employer and the Home Office, whereby the Home Office commits to enabling you to bring skilled workers to the UK with systems to facilitate those moves in return for you agreeing to sponsor those workers. Sponsorship in this instance means ensuring that the person will be compliant with the immigration rules, that they have the right to work in the UK, that they will be paid at the proper level, the level that you said that they would be paid when they came to the UK, that they will be operating at a skilled level, that you will know where they live and work in case the Home Office needs to contact them, and that if their circumstances change or if they fail to turn up to work on their first day or for an extended period, you will report that to the Home Office. It feels rather Orwellian, and it is very complex. You have to take it very seriously because mistakes in sponsorship can mean that you lose all of your sponsored workers, but also face civil penalties and in the worst cases, criminal sanctions. But it's manageable if you take the time to understand and learn the rules and expectations. The process of becoming a license holder, really, you should assume that it will take you right now between 1 and 3 months, probably between 2 and 3 months. Assume a week to a month to get the documentation together, and that documentation is paperwork that demonstrates you'll be able to meet the sponsor duties I've described, but also that you are a real and active employer. And then assume a 1 to 2 month wait for the Home Office to process the application, although it can go a little bit quicker. What we're very conscious of is that while there's around 30,000 sponsors in the UK right now, that number will need to increase when free movement ends. I'm not aware of any huge increases in application numbers to the Home Office at the point that I'm recording this webinar, but it must be due at some time. I recommend that you apply sooner rather than later so that you aren't at the back of the queue if a longer queue does form. But please don't jump straight into it. Take the time to research what's involved, take a look at sponsorship guidance and other guidance on the Home Office website, or speak to an expert and take it really seriously. It's really important to get it right. Once you are a sponsor, you will be able to sponsor workers under two main categories: skilled worker and intra-company transferee. The skilled worker category is based on what is currently called the Tier 2 General immigration category. If you're familiar with Tier 2 General, you'll know that right now there is a labour market test that means advertising for 28 days and checking no suitable UK nationals are available. That policy will be going under the new immigration system. There is also a cap on numbers right now, which creates uncertainty where the cap is exceeded and your employee may not get through, but also creates delays. Typically, those delays will be somewhere between a week and a month and a half, depending on when you're applying. The cap is being suspended for the time being, so you don't need to worry about it until or unless it comes back in. And then the final point here is also that this system will be for all nationalities other than UK nationals, and again, other than Irish nationals. So how will it work? So essentially, your first job, having identified the person you want to sponsor, will be to ensure that they meet the points test that we can see on the table. Employed by an approved sponsor is where the sponsor license comes in. You will demonstrate that by assigning a certificate of sponsorship to the individual. They will need to be in a skilled job, And for these purposes, skilled work means work that is at RQF level 3 or above, which is A-level level. And they will also need to have be able to evidence English language competence. That can be by being from an English language speaking country or a recognised English language speaking country. South Africa, for instance, isn't recognised as English speaking. Several others aren't, which can come as a surprise. Or from holding a degree which is shown to be taught in English. In some instances, other qualifications too, or by passing a prescribed and recognised English language test. The worker then needs to be paid a sufficient salary to qualify. So there are a few aspects to salary. At its simplest, for most workers, they will need to be paid at least £25,600 a year in salary. However, for some workers, that minimum salary will be lower. So as you can see, it will be lower and could be as low as £23,040 if you have a PhD in a relevant subject, or as low as £20,480 if you are in a shortage occupation, have a PhD in a STEM subject, or you are a new entrant. By new entrant, the Home Office is thinking about such things as such characteristics as being aged under 26 or being a reasonably recent graduate. A bit more detail to that, so do take a look at the guidance. But it does mean that people straight out of university or out of university reasonably recently can go in with a salary lower than £25,600. However, the minimum salaries don't start and end with what we can see on here. For each job in the labour market, there is also what's called a going rate set in Home Office guidance and rules. And that going rate is the minimum salary that needs to be paid for that particular job. If you are planning to be sponsored in a IT stock code, for instance, stock code being the terminology that's applied, but for IT jobs, the minimum salary will tend to be somewhere between £30,000 and £35,000. Other graduate jobs will tend to be in the order of £30,000 or a little higher, sometimes a little lower. So firstly, your worker needs to be paid at least the £25,600 or the £20,480, depending on the circumstances, or the going rate for the job, whichever is higher. And the going rate for the job can be prorated and lowered, where points would be awarded at a different level, such as new entrants or people holding a relevant PhD. Do take that really seriously. It's a Home Office policy to prevent undercutting of UK workers, and they understandably take it very seriously, just as I'm sure you would. The final point I'll make, the final 2 points, sorry, I'll make for skilled workers are, firstly, this is potentially a permanent category. So having entered as a skilled worker, 5 years later, it will be possible for your employee to apply for indefinite leave to remain, so long as they have not had excessive absences from the UK. So it's a good category to bring people in and to keep them. But it's very expensive. So if you were a large employer and you were sponsoring an individual for 3 years, you would be looking at government fees of about £5,700. If you were a smaller employer and sponsoring in the same situation, you would be looking at similarly high costs, but closer to about £3,500. So big numbers involved. Where they have a family member, for every a family member who is entering for 3 years, they are broadly looking at around £2,500. All of this is just in government fees. Big costs. It's something to plan for and budget. In addition to the skilled worker category, the intra-company transfer category that already exists in the immigration system will be rolled over. This is for employers who need to transfer a worker from an overseas entity to the UK. That entity needs to be linked by common ownership to the UK entity. The individual typically needs 12 months experience, although graduate trainees can qualify with 3 months experience, and to be paid £41,500, although again, graduate trainees can be paid less. In both instances, the going rate for the job will apply. The ICT category is typically limited to 5 years stay in the UK. It's a good category for moving current company employees into the UK quickly, even where they do not have evidence that they speak English language. However, my sense of it is that in most instances, we will find ourselves recommending that individuals our clients are looking to sponsor come over in the skilled worker category, because it will take about the same amount of time to land someone, so probably about a month when the system is up and running well, including document collection. But under the skilled worker category, people can stay permanently. If you are familiar with the ICT category that's in place at the moment, you will know that there's a cooling off period, which means that in certain circumstances, a worker cannot return to the UK for 12 months with a work visa from the point that their sponsorship has ended. That won't be quite as blunt under the new system. And instead, the Home Office will say that individuals can only spend 5 years in the UK in any 6-year period, unless they're a very high earner. The other benefit to this, the other flexibility that the Home Office are introducing for this category is the opportunity to move from the ICT visa into the skilled worker category. That's not been possible in the past, but it means that if you are sponsoring ICT, people in the ICT category at the moment, and they want to stay permanently and you want to keep them here permanently, it will be possible for you to move them into the skilled worker category and for them to start a clock towards permanent residence after 5 years. It also means that you will be able to recruit people holding an ICT visa where you couldn't before from competitors and other employers, but equally that your competitors and other employers could recruit ICTs from you. It's a good policy that helps workers and employers. Moving on to graduates. So my sense is that when we come to looking in detail at graduate recruitment programs with clients, in most instances, we will be recommending that they use the skilled worker category that I talked about a few moments ago. It leads to settlement reasonably quickly, and it should work well for most people. It is more expensive than some other options, but other options are time limited. There is also the intra-company graduate trainee category. That's a good option for a limited number of people where you are hoping to move people on a graduate rotation program around your multinational offices and can work well for up to a year. And really helpfully, there will be a new graduate visa category from the summer of 2021, which will allow people to stay in the UK for 2 years, having completed their degree, or 3 years for PhD, and then subsequently move into the skilled worker category. This will be a good thing for universities and a good way to pick people up who may not be, a bit like I wasn't, who may not be immediately ready for a graduate program or a graduate job straight after university. The graduate category will allow, we understand, we need to see the law, but we understand it will allow people to work at any level in the labour market, including lower skilled work. But the skilled worker and the ICT visa do not. Skilled worker category visas will be limited to people in RQF3, so A-level jobs and above. The ICT category will be limited to people in degree level jobs and above. It may be that you find a candidate overseas who you need, who will be taking a lower skilled job. It will not be possible to sponsor them. However, it may be possible for them to achieve what can be loosely defined as self-sponsorship. Under UK ancestry, if you have a grandparent born in the UK, Commonwealth, if you're a Commonwealth national with a grandparent born in the UK, you can qualify for UK ancestry and work for 5 years at any level in the labour market before applying for indefinite leave to remain. Spouses and partners of UK nationals and people settled here can also apply for a visa to live and work in the UK and again take employment typically being granted indefinite leave to remain after 5 years or 10 years. The youth mobility category is essentially a backpacking category that will allow people to move to the UK for 2 years where they are aged 18 to 30 and qualify as being from a youth mobility country. So for instance, Australia, Japan, Canada, New Zealand, and 1 or 2 others. Students can work in some circumstances, but can often be limited to the number of hours they can work for a week. Do keep an eye on that, because the Home Office is very, very keen that students do not work too much, or indeed that they aren't exploited, and quite rightly so. Or you may find a candidate who has indefinite leave to remain in the UK, where an individual has indefinite leave to remain. Just like people in all of these categories, they can work at any level in the labour market. So there was an awful lot there. What does this mean in terms of planning? So a few decisions for you to think through. Firstly, do you need a sponsor license? If you don't have one already and you're going to be sponsoring or at least attempting to recruit from overseas in 2021, I recommend that you apply, and you apply soon, so that you're not at the back of any queue that forms. Don't rush too quickly into it. Make sure that you understand fully what's involved in becoming a sponsor, and you understand the licensing application process. If you already are a sponsor and you have people who hold ICT category permission, who probably assume that they are limited to 5 years stay in the UK, have a think about whether or not it would be in your interests and their interests for them to move into the skilled worker category. Think about graduate recruitment. The skilled worker visa will work perfectly well in most instances, so long as minimum salary requirements can be met. But do take a look at that, and also keep an eye out in the summer, and I'm sure there'll be lots of coverage, and that the Business Hub will provide some information. I'll look out for the graduate visa. Minimum salaries are important. I've talked about the need for your workforce to earn a certain amount of money and be working at a certain skill level to be able to qualify to come into the UK with sponsorship. Have a look at the pockets of your business that have a high dependency or benefit an awful lot from European and indeed non-European workers, and have a look at whether or not the salary requirements will be met, whether it's those salaries in the table I mentioned or the going rates for the job, and the skilled requirements will be met. If they won't, it may mean that you need to make some adjustment to how people are paid, or it may mean that you need to make some adjustment to how the work is completed. Maybe thinking about how you find people looking for other sources of labour. Right to work is rather complex, so I'll come to that in a moment. On covering costs, UK immigration is really expensive. You have to take this seriously and budget plan for what it will cost you, but you should also have a think about how much of the cost you will be covering. The law, if we say that you're a large employer taking someone on for 3 years and sponsoring them, that will be about £5,700 in government fees. The law assumes that you will pay the first £3,200 of that for the skills charge and the certificate of sponsorship. Only the employer can pay that. You cannot pass that cost onto your employee. But the law allows you to cover the cost, the remaining cost for your employees, when they pay around £2,500 on an immigration health surcharge and on their visa, along with any additional costs relating to the move or priority immigration services to push an application through more quickly. Have a think about the extent to which you will cover those costs. In my experience, it's quite a mixed picture, but it's not uncommon for employers to pick up costs for their prospective employees, although some do have policies around the instances where they will also cover costs for family members. And then finally, we don't have much time left, but do think about whether or not you can move people early. If they are European and can come in before the end of free movement, it will be possible for them to avoid the cost and the admin that goes along with sponsorship. On right to work, just to finish off. So right to work until the end of the year, if you're recruiting a European, you simply need to see, copy, certify and record a European passport to know that that person has the right to work and that you have a statutory excuse against illegal working. From the beginning of July next year, you will also need to ask to see that they have permission to work in the UK, and that might be the permission under the EU settlement scheme or a skilled worker visa. But for the first 6 months of next year, while the employer expectations will not change, you will simply need to see that they have a European passport, certify, record it, and so on. In the background, the individual will also need to hold the right to work, and if they don't, then at some point in the future, when that becomes apparent, they will find that it's harder to work, to rent a flat, to access healthcare, and so on. All of the hostile environment controls that I talked about. And this might be for people who would have qualified for under the EU settlement scheme, or people who arrive fresh in February without appreciating that they can't just come over here and work anymore. Have a think as an employer. Speak to your employment lawyer as well, because your approach will differ according to your risk tolerance and other policies. But do you ask your prospective candidates whether they have the right to work, and then guide them as to what is possible if they do not. So to finish off, just to get things going, there's so much to all of this. I could not cover all of it in a half-hour webinar, and you really I know I've stressed this an awful lot, but you really must, if you're going to be taking any of this forward, check out the law or speak to an expert, because if it goes wrong, it can have really serious consequences for you as an employer, but also for your employees. But to get things going, begin by communicating policy and challenges. Have a think about who in your organisation ought to have applied under the scheme, and like I say, reassure them that they can stay, but educate them on the policy and the process, and direct them to apply on time. Map your policy, this policy against your workforce to understand whether or not you will be able to recruit in the way that you have been in future once free movement ends. What do the salary requirements mean? What does the cost of all this mean? Do the skill requirements limit who you can get to do work at particular jobs for you? And do you need to rethink your workforce plan? For many of our clients, we're basically looking at the pockets of workers who are from Europe and are particularly important, if not all of them, and looking at will they qualify for a visa, and if not, what other options are available. And again, communicate that to the business. Make sure that line managers, make sure that senior leadership understand this, understand the risks, understand the issues, and understand the cost. And then follow all of this. It's possible to sign up for Home Office alerts. The London Business Hub provides really good resources on regulations across the piece, not just this. Take the time to sign up for alerts to stay on top of these things. We're not alone in this. Other law firms, many of them do the same thing, but we have a page on our website where you can sign up for alerts to get notifications when the law changes. Have a look at where you can get that information so you can stay on top of things. And then finally, please take it seriously. It's been such a hard year for planning with coronavirus, but this is really very serious, and it is happening. It will change the way that you think about workforce planning. If you don't have a sponsor license and think you will need one, apply for one. If you do have a high or a important number of Europeans working for you in the UK, do have a look at whether or not they would be able to, if they were joining you from the beginning of January next year from overseas, and whether or not you need to make any adjustments. So I'll stop there. Thank you for listening. Thank you to the London Business Hub for hosting this webinar, and we hope it was very helpful. Best wishes and take care. Bye-bye.